Approximately 6 months ago, we resolved a case where my clients engaged this law firm who specialized in estates and trusts to prepare an estate tax application and submit it to the federal government. My client's parents had died within recent times, and they left a rather significant estate, millions and millions of dollars of assets, two of which were ocean properties on the beach in New Jersey. The lawyer who assumed the responsibility to file the estate tax application projected tax liability at approximately $200,000. Unfortunately, he filed the tax application late, but more importantly, within 6 months, the IRS sent my client a deficiency notice, which ultimately produced approximately $3 million in tax liability, including taxes, principal, and interest. You don't have to be possessed of any great genius to know that my clients were very upset. Fortunately, they were able to find a very special lawyer who had spent maybe 30 or 40 years litigating cases against the IRS in situations just like this. That lawyer, after almost 3 years of litigation, was able to drive down the government's $3 million claim to just about what it was in the beginning. But unfortunately, that lawyer was paid over $555,000. That's a significant element of damages. That damage element in that case was further confounded by reason of the fact that my clients had to pay the carrying charges on the properties for 3 unnecessary years, and more importantly, in that 3-year period, the real estate market in New Jersey fell out the bottom. And the diminution of value between what the property was when the estate should have been settled versus what the property was when the case was ultimately settled was significant. We sued the law firm, and after a year or so of litigation, the case was ultimately settled. My client was very happy with the recovery, and so was I. Today, I am working on a case where I represent a young widow and an infant daughter. And in this case, the young lady's husband engaged a lawyer to create a trust where the client, my client, was to be a principal beneficiary, and her daughter, along with her step sisters and brothers, were to be beneficiaries as well. The trust was to be funded by a $1.7 million policy, which the husband purchased many years earlier at a time when he was married to another woman. When he purchased the policy, he identified the woman as the beneficiary. The lawyer prepared the trust document and transferred the ownership of the life insurance policy to the trust, but failed to pay or failed to change the beneficiary to show the trust as the beneficiary. In time, the husband sustained an untimely death. And before long, it was learned that the first wife, the ex-wife, and not the current wife, was the beneficiary of the $1.7 million trust. My client engaged a law firm, considered by some to be the biggest and best in North Jersey. They filed a reformation action, which is simply a lawsuit asking a judge to reform the insurance policy to comport with the intent of the testator, who was the husband, which, according to my clients and her lawyer, was that the husband intended the policy to be the funding for the trust. The case ultimately settled. There were a number of complications associated with the settlement. We have recently filed a lawsuit against the individual who prepared the trust because he failed to make the insurance policy, fund the insurance policy to the trust by making the trust the beneficiary, and we have sued the law firm for other circumstances associated with that case, which are a bit too complex to explain at this time.